Blog Talk Radio.
Welcome to Family Law Talk.
Family Law Talk.
Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a family law firm with offices in Missouri and Illinois. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. We have an interesting topic today. The topic is, how long will my case take? This is one of the most common questions clients going through family law matters ask of their attorney right out of the gates. It's something they definitely want to know about, and they're looking for a time frame in which the case will be over so they can hopefully move on with their life and move past the case. So definitely a common question, an important topic, and one that we wanted to cover today in the episode. As a follow-up to the episode today, you can go to familylawheadquarters.com, and we have a blog article on the same topic dated November 22nd, 2015. So as a follow-up to the episode, you can check out the article. Definitely would be a good follow-up to the episode here today. But again, the question that lots of individuals going through family law cases have right out of the gates is, how long is the case going to take? When will it be over? When can I move on with my life? And when can I get out of court and not pay attorney fees and not have to go through the pain and trauma of the entire process? And so an important question, one that certainly makes sense for somebody to ask in going through a family law matter such as a divorce or custody case, and definitely one that right out of the gates is on the minds of most folks. The dilemma in answering this question for most family law attorneys is that after an initial meeting, really early in the case, it's really hard to give the client an exact time frame, and more than hard, it's really impossible, because at the end of the day, these cases can really go in three different directions. In a generic sense, if you look at these cases, and depending on the direction that the case goes, you can have a big variance in terms of the overall time frame, and it's just hard, if not impossible, to be real definitive right out of the gates, having first met a person. And so let's kind of go through the different scenarios and talk real generally in terms of time frames that clients might expect. And one of the things I like to do in talking with clients and potential clients is go through these scenarios and have the client or potential client then analyze where they think they might end up. Because once it's broken down, then most individuals can assess their own individual situation and have a more realistic assessment in terms of what the time frame might be. But let's go through these. Scenario one is the case is where the parties are just categorically far apart. They want totally different things. They have different goals. They have different aspirations. The viewpoint of one of the parties in terms of what's fair and reasonable is completely opposite of the other party to the family law litigation, whether it's a divorce or custody case. They are just polar opposites in terms of what they want. So take a custody case where both parents want sole custody. They don't think joint custody could work. And it's sort of a winner-take-all kind of scenario. It could be a case like that. Take cases where spousal support, also called maintenance, could come into play. One of the spouses wants spousal support. They think they absolutely need it. And then on the flip end, you've got another party who's absolutely opposed to paying. They think they shouldn't have to pay. They think their spouse would be able to support themselves, meet their own reasonable needs. And so you're not talking about a discussion or a discourse in terms of how much spousal support would be paid or for how long. You're stuck in a case like this on the initial question, which is a disagreement on whether or not it's even going to be paid or not. And again, I'm just trying to give you some examples. In some cases, both parties want the divorce. They agree that the marriage isn't working, and they're ready to move on. But there are certain cases out there where one party just wants to save the marriage. They want to contest a divorce. They just don't agree to being divorced in any really shape, matter, or form, and they're willing to go to court over an issue like this. Those are tough cases. Relocation cases where one parent might be wanting to move across the country with the kids, so the kids will be far away from the other parent. Again, these are winner-take-all type scenarios. And when you look at a case like this, the parties are just on opposite extremes. So again, I'm just trying to give you some examples. There are really a litany of examples we could go through. But in cases like this where both parties are just opposite in terms of what they think is fair and reasonable. In cases like this, really the only way to resolve the case is through a trial or an evidentiary hearing, and then the judge has to make a call. And after the judge makes a decision on a case like this, oftentimes one or both of the parties still aren't happy. And so you could have an appeal. The appeal process can take a substantial period of time. It could be a situation where maybe there's not an appeal, but a short time later the parties are back in court on a motion to modify or a motion for contempt, and they're trying to litigate the matter again. And in cases like this, the truth of the matter is these cases can take many, many months. Sometimes they can take years. There are cases where parties, unfortunately, are just tied up in the court system for years in terms of the initial case and then motions to modify, motions for contempt, and other really ancillary action that there might be. And so, again, these are the worst case scenarios. Obviously, nobody wishes this upon anybody, but they're just these cases out there where the parties are so opposite in terms of their expectations that these cases can take a long time, and these parties can be in litigation theoretically for years. So that's one extreme. And again, certainly no attorney wishes this for anybody, but there are cases where this is just the case. On the other end of the spectrum are the cases where the parties are really very close in terms of what their expectations are. They might see things relatively the same. It could be an uncontested divorce where both the parties agree that the marriage isn't working and that they're going to get divorced. Could be a situation then as well where the parties both agree to joint custody or some type of custody agreement that they think works for the family, works for both parties. When you get into child support and maintenance, these are oftentimes the cases where there isn't a debate about whether or not child support or maintenance is going to be paid. The parties sort of agree on these issues, and it might just be, on the numbers, and the numbers have to be worked out, but ultimately the parties are able to reach a decision very quick and do the case and finish it and complete it in an uncontested manner. Now, if I took a survey of most folks who come through the door at our law office, at least, this is where most parties want to be. Most parties want a simple, easy case that can be completed amicably. The dilemma is the devil's in the details, and oftentimes parties have totally different viewpoints in terms of what's fair and reasonable. But there are some cases where the parties are able to agree. They're able to do the case on an uncontested basis, and these are the cases that can really be completed relatively quick. Parties don't have to be in the court system very long. It's just a matter of really pushing the paperwork through. In some jurisdictions, getting a non-contested hearing. In some localities, these types of cases can often be completed by affidavit as well. But again, these are the quick, easy, simple cases. But even cases like this can take several months. By the time the parties do a little bit of negotiating, they get the settlement paperwork put together. They both have an opportunity to review it and sign it. Can take a few months. In Missouri, for example, there's a 30-day wait period on a divorce. So from the date the divorce is filed, the case can't be completed during that 30-day wait period. So the absolute quickest a divorce, for example, could be completed on an uncontested basis would be, really after that 30-day deadline, so 31 days after the case is filed. So that's the absolute quickest. That's tough. That's the parties really moving expeditiously. And then you've got to work with the judge's schedule in terms of setting a time for a non-contested hearing or being able to present the paperwork to the judge for a signature if it's being done by affidavit. But those are the easy cases. And then you have these middle line of cases where the parties right out of the gates don't agree. They've got different viewpoints that are out there. It might be that they agree on 70, 80, 90% of the issues that are out there, but they get hung up on 10, 20, or 30% of the issues, right? So they get hung up on some issues like this. But ultimately, cooler heads prevail. So it might be a situation where there were multiple court dates. Could be a situation where discovery was done, interrogatories, requests for production, for example. Maybe it was a situation where depositions had to take place. But ultimately, cooler heads prevail. And in some of these cases, this literally happens on the eve of trial, the weeks leading up to the trial. I've even seen cases settle on the day of trial. The parties ultimately come to some sort of accord, some sort of agreement, and they resolve the case. And these are really your middle camp of cases. In a generic sense, from my experience, most cases sort of end up here. Most cases don't go completely on the extreme, and most cases don't settle as easily and quickly as most parties want. But most cases sort of end up here somewhere in the middle. And cases like this can take months as well. Sometimes it can take more than a year for the parties to reach some sort of settlement agreement. But these are your middle road cases. And so when you look at the length of a case, parties want to know out of the gates how long the attorney thinks a case might last, when the case might be over with. And in a really generic sense, you're looking at these three camps. And the question for the client right out of the gates is looking at their situation, looking at their fact pattern. Of course, they know the other party better than the attorney. I mean, if it's a divorce, for example, they were married to the other person or still married to the other party. They know whether they're reasonable or not as well. And at the end of the day, what the likelihood would be for them to either reach a quick settlement. On the flip end, the parties have to go to trial, and there's a lot of subsequent litigation or these cases in the middle where it doesn't take as long as the extreme cases, but it's not as simple and easy as some folks want as well. So while individuals are looking for a definitive time frame, it's really an impossible thing for an attorney to give right out of the gates because there's just so many unknowns. But at the end of the day, potential clients, the thing to ask yourself is, where do you think you might fall in terms of these three potential categories of cases? And that can kind of lead you to really having a reasonable conclusion about how long the case might ask. Of course, at the end of the day, the variables are always out there. There's no definitive time frame any attorney can give. And that's just really the truth, even if a client is looking for some sort of definitive answer. Again, that's the topic here today, how long my case will take. As a follow-up to the episode, you can go to familylawheadquarters.com. You can check out the article dated November 22nd, 2015, titled, How Long Will My Case Take? So that's the episode today. Stay tuned to our next episode of Family Law Talk coming up. Thank you very much.
Thank you for listening to Family Law Talk.
Family Law Talk
with Kirk Stange. Visit StangeLawFirm.com for more about today's topic or to put Stange Law Firm to work for your family today. The choice of a lawyer is an important decision that should not be based solely upon advertisements. Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtain on this podcast is not, nor is it intended to be legal advice. You should contact an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. And finally, past results afford no guarantee of future results, and every case is different and must be judged on its own merits.
Kirk Stange is responsible for the content. Principal place of business, 1750 South Brentwood Boulevard, Suite 401, St. Louis, Missouri, 63144.
Go Ford for your next truck or SUV and find an easier way to buy with Woodhouse Ford today and experience the convenience of buying with Woodhouse Ford. Save up to $13,000 off MSRP on a 2023 Ford F-150 XLT plus 3.9% APR for 60 months with approved credit. $299 doc fee due at signing. Security deposit waived. Expires 1/02/2024.
Okay, round two. Name something that's not boring.
A laundry? Ooh, a book club. Computer solitaire, huh?
Ah, sorry, we were looking for Chumba Casino. That's right, ChumbaCasino.com has over 100 casino-style games. Join today and play for free for your chance to redeem some serious prizes. ChumbaCasino.com. No purchase necessary. Void where prohibited by law. 18+ terms and conditions apply. See website for details.